Okay, and as I said, this is Ayers Basement Systems versus Foundation Systems of Michigan, docket number 20-335CB, and this is the time set for hearing on the defendant's motion for summary disposition. This is brought under MCR 2.116C8 as to Foundation Systems of Michigan and under C10 as to Cortec Group. And as we get started here, I'll let you all place your appearances on the record, starting with plaintiff.
Good afternoon, Your Honor and brethren counsel. Michael Matheson appearing on behalf of the plaintiff, Ayers Basement Systems, LLC.
Good afternoon, Your Honor. Gary Gordon appearing on behalf of the defendants.
Good afternoon, Your Honor. Paul Peralta appearing on behalf of the defendants.
Good afternoon, Your Honor. Benjamin Shook on behalf of the defendants.
Okay, then we're all set, and this is the defendant's motion. Whoever is arguing it, go ahead.
Thank you, Your Honor. This is our motion, and maybe a little bit of background will help set the context for the motion. We do represent Foundation Systems of Michigan, Incorporated. This is a business that our client, Groundworks Operations, LLC, purchased earlier this year. Our client, Foundation Systems, is based in Livonia and has offices in Grand Haven and Traverse City. Groundworks, which is the parent, is actually based in Virginia Beach. And Groundworks operates a number of these so-called dealers like FSM throughout multiple states. FSM is in the business of basement waterproofing and foundation repair work. And they primarily service residential customers. Customers who have these problems will contact us and we'll send a crew out, and the crew will assess what the problem is and then make a repair. FSM actually started in business in 2007. And at the time that they started business, they became affiliated with an organization called Basement Systems. Basement Systems is part of a larger business called Contractor Nation based in Connecticut. And Basement Systems, like Groundworks, has affiliations with certain dealers located throughout the United States. In fact, they're quite large. And FSM, for a period of time, was one of those dealers, as was Ayers Basement System. However, and this is affirmatively alleged in the complaint, in December of 2019, FSM exited that network. In other words, it ceased being affiliated with Basement Systems and went out on its own to do business in the state of Michigan. And therein lies the dispute between the parties. Ayers continues to be a dealer for Basement Systems, but as I mentioned, there's no dispute that FSM exited the so-called Basement Systems network. I think it's important to understand as well, Your Honor, that Basement Systems network is not a franchisor-franchisee type of relationship. It is a relationship based on the provision of certain services, support services for dealers, as well as certain products and supply. But once we exited, we no longer were in need of those. And as FSM continued to do business, it did so independently. So what we have before the court then is a 4-count complaint that has been filed against FSM by Ayers Basement Systems. They have improperly named the Cortec Group Fund 7 Limited Partnership, and I'll get to why they need to be dismissed as a matter of law shortly in my remarks regarding the basis for a motion to dismiss. The crux of this complaint is a claimed breach of an unwritten, quote-unquote, non-compete agreement between two competitors, Ayers and FSM. What Ayers asked this court to do is to recognize a horizontal restraint on trade that is per se illegal under the Michigan Antitrust Reform Act. It's illegal in terms of its content. It is also invalid and unenforceable based upon its formation. because it violates the Michigan statute of frauds. It also fails to satisfy the prima facie elements for the formation of a contract because of lack of mutual assent. And as a result of that lack of mutual assent, the contract of an indeterminate or indefinite time is also terminable at will, and it was terminated by FSM. So I'd like to address very briefly first the per se horizontal restraint problem and issue presented here. As we mentioned, that this is a matter that's controlled by the Michigan Antitrust Reform Act, which makes clear in following Section 1 of the Sherman Act that horizontal restraints are per se illegal. And that's what's attempted to be enforced here. The plaintiff alleges that the purported agreement, what they refer to as a non-compete agreement, is actually between two competitors. Notwithstanding their effort to try to inject basement systems into the picture, paragraphs 6, 7, 10, 11, and 17 of the complaint make it clear that this was a territory allocation between two competitors, Ayers and FSM. If I didn't mention this before, Your Honor, it does bear mentioning, and I don't think there's any dispute, that Ayers is in the same line of business. They do basement waterproofing work and foundation repair work. When there is a horizontal restraint of trade, as there is here, it's clear that under U.S. Supreme Court precedent, under the Topco case cited in our papers, as well as Michigan case, the Michigan Manitou, and the Medill cases cited in our papers, as well as the Sixth Circuit Cooperative Theater case cited in our papers, those are, as a matter of law, illegal. Now, the effort to try to inject or insert a perspective here that this agreement is, in fact, a vertical form of agreement is unavailing for several reasons. And I think the primary reason it is unavailing is that relationship, the basement systems, Ayers, FSM relationship, ended in December of 19 when our client exited that affiliation with basement systems. So from that point going forward, FSM was no longer bound by any agreement, however formal or informal, and we will submit it was very informal, with respect to allocating territory. Once we exited the system, exited the network, we were no longer provided with the same benefits that are alleged in the complaint, the support services, the products, the supplies, and the like. So we simply exited, as was our right. And to the extent that there's any issue regarding enforceability, I think it's important to understand that the only party seeking enforcement here is Ayers. It's telling that the so-called vertical party in the arrangement is not a party to this lawsuit. They have not attempted to enforce any form of agreement against us because there is none, nor have they insisted that any type of territory allocation be honored, because to the extent there was any allocation, that is over. And so what we have now is a direct effort by a direct competitor, a horizontal competitor, in fact, to restrain trade by limiting our ability, or attempting to limit our ability to do business in the state of Michigan as compared to the territory that they insist is applicable. But not only is there a problem, as we mentioned, with the notion of a content defect, and the content is severe here because it is a manifest restraint in trade. But the equally defective and fatal feature of this so-called agreement is that it fails in formation. Your Honor, to our knowledge, and we've looked under Michigan law, and in fact, we've looked under both state and federal law interpreting Michigan, both common law and statutes. This is the only case that we have found, or at least this is the only case we have ever seen, let alone found, that attempts to enforce a wholly unwritten non-compete agreement. And that is a fundamental and fatal flaw to this entire case. Because what is at issue here is whether or not a party can be bound by an agreement that is so manifestly in violation of the statute of frauds. The statute of frauds here applies because this is a purported arrangement that was intended to last more than 1 year. And there's no dispute from the other side that this was an agreement that was intended to last more than 1 year. And under Michigan statute of frauds, then there were fundamental requirements. One of those requirements is that there be a writing. And the second requirement, equally important, is that the party to be bound, the party to be charged as to enforcement of the agreement, must have signed the writing. What plaintiff hangs their hat on for writing purposes is a November 8th, 2017 email that refers to an agreement, but is not an agreement. It refers to certain discrepancies in territorial maps, but it doesn't contain essential terms and conditions that would manifest and exhibit a meeting of the minds. In fact, more importantly, that email shows that there was no meeting of the minds. It shows that there was a standing dispute with respect to what constituted separate areas, and that is what is relayed in that email. But that email is not signed by anyone at FSM, and the statute is clear; it must be signed by a duly authorized representative. And nor does it contain the essential elements of the agreement. Now, our opponent would argue that there are no essential elements necessary for the statute of frauds. But here we're talking about a different form of agreement. And that agreement would be in the context, in terms of their label, a non-compete. And in order for a non-compete to be analyzed, and putting aside the context of an employer-employee relationship, whether it's employer-employee or otherwise, there are certain fundamental terms that need to be contained in the writing. The durational term needs to be contained in the writing. The scope of the restriction in terms of geographic restriction needs to be contained in the writing. And finally, the activity that is being restrained. What is the activity that a party is agreeing to refrain from engaging in has to be at least specified. And there's no writing whatsoever that contains those elements. The first time that our client saw anything with reference to a duration was not in a writing that it signed, but it was in the allegations of this complaint and in the briefings that followed. The duration that Ayers claims applies here was in the disjunctive. They claimed that the duration was either for the period of time that FSM was a member of this so-called network, or, and this is the key part, or for a reasonable time thereafter. That's the allegation. Again, that's not part of a writing in which our client in any way signed or acceded to. I think, from a very practical standpoint, the statute of frauds does not contemplate that an opposing party's allegation in a complaint suffices as the writing. The statute of frauds needs to be in some form or manner adopted by the party to be bound. And we did not adopt or sign the pleadings in this case. On a second level, there is a lack of an essential term, which is the scope. The very document that they claim manifests the scope, the territorial limitation, by its terms shows that there is a discrepancy. In fact, Ayers admits as much on page 18 of their response. They say there's a discrepancy here. Well, I think there's more than a discrepancy. In fact, there is what FSM's former owner referred to as a great difference between what Ayers understood a territory to mean versus what our client understood the territory to mean. So there was no meeting of the minds, which really segues to the second fatal deficiency here. There has to be mutual assent to have an agreement. So putting aside the fatal defects that they have with the statute of frauds, there needs to be a meeting of the minds. There certainly was no meeting of the minds with respect to the duration. Again, the first time our client saw anything with respect to duration was when this complaint was filed and the subsequent arguments made on the papers. But even then, even by their own terminology, they show that there is indefiniteness there because of the disjunctive. Either the contract lasted during the term of the relationship that FSM had with Basement Systems, or quote, for a reasonable time thereafter. Because of that lack of definition, under Michigan law, a contract then is terminable at will. That's exactly what our client did. Our client said, as of December 2019, when we exit this network, we are no longer bound by its terms, and we are moving forward. And we did. And so our actions were consistent with Michigan law because, again, assuming that a contract even existed, it was indefinite as a matter of law. Related to this, Your Honor, finally, on the issue of the second, third, and fourth counts, all of these are derivative of this concept that there is a binding and enforceable agreement. For example, on count 2, on the intentional interference in business relations, it is premised by its allegations on this agreement. Since there is either no agreement due to lack of formation, or there is, in fact, an agreement, but there is an horizontal illegal arrangement between two direct competitors who are competing inter-brand versus intra-brand, then there can be no foundation by which an intentional interference of business relationship claim can be made. And the same holds true with promissory estoppel. The promissory estoppel claim, again, is premised on this notion of the non-compete. They affirmatively allege that the non-compete is the genesis of their promissory estoppel claim. If the agreement is illegal in form and in substance, then it is also means that the promissory estoppel claim is irrevocably infected with that problem and also must be dismissed. And finally, Your Honor, there is this issue of Cortec. We submitted in our papers an affidavit from our chief executive officer at Groundworks Operations LLC that is the entity that acquired FSM, and it was the only acquirer. And that entity is separate and apart and distinct from Cortec at many levels. And therefore, this notion of vicarious liability, if that's what is being addressed here or alleged, is simply inappropriately addressed with respect to Cortec, who has no direct corporate affiliation with FSM. So, Your Honor, for the reasons that I hope I've articulated in a clear fashion, we think this complaint should simply and summarily be dismissed for failure to state a claim because of not only content of what's being alleged, and as this court well knows, Michigan law firmly is within the majority of jurisdictions that illegal contracts will not be enforced. And secondly, that we have fatal defects in formation, that we completely lack a writing by which these various restrictions can be measured under any standard. So for those reasons, Your Honor, we ask that the court dismiss these claims.
Thank you. Mr. Matheson?
Thank you, Your Honor. And I know that you have read the briefing on this motion. I will characterize the argument by Mr. Peralta as a mostly repeat of the motions. That's not to be derogatory in any fashion, but by in no stretch based on my limitation of argument as it's contained in the brief, that mostly addresses Mr. Peralta's oral arguments. I will make a few points of clarification and additions to what has been stated in the documentation and in response to Mr. Peralta's argument. As this court is aware of the standard under motions under C8, this is based on the pleadings that have been presented to this court in the form of the first amended complaint. That complaint clearly and plainly alleges a three-party agreement between Ayers Basement Systems, Foundation Systems of Michigan, and the basement systems, we call it the network. There were three parties to that agreement. Despite the arguments that are being made, this is not a horizontal agreement between only Ayers Basement Systems and FSM. It involves a supplier distributor of product on an intra-brand basis, and that's what it was formed on back in March of 2011. That is the genesis for the agreement. It is a single agreement. It's not an agreement that was effective in March of 2011 only to become a different agreement, as I interpret the argument, written and oral argument, that when FSM departed its dealer status with basement systems, that this somehow morphed into a separate non-compete agreement and is unenforceable as of this point because it's only between Ayers Basement and FSM on a horizontal basis. This was one agreement made in its entirety between three parties in March of 2011. So the pleadings, in my opinion, are clear on that point, that this is a single agreement and not two separate agreements, which is how I interpret the defendant's arguments on this point. And in addition, the agreement itself, the horizontal versus vertical nature of the agreement, as I indicated, is determined on the inception, as I called it in the complaint. The non-compete agreement is determined at the inception of the agreement and not at the point in time that FSM opted to depart as a dealer from the Basement Systems network. Now, I know Your Honor is well aware of the rule under 2116I5 regarding amendments. I don't believe one is necessary, but I certainly reserve the right to file one to the extent this court determines or grants the motion. And if there is a possibility of preserving claims, I certainly would like to do so. And in particular, as it relates to this and versus or provision, I addressed that in the response, and I certainly made an effort to reflect what was intended by the paragraph. It certainly wasn't to suggest that there were two separate agreements here, that one agreement was in place during the point that these parties were part of the dealer network and some other agreement was created after one of the two dealers left the network. It's all part of the same non-compete agreement that is set forth in the complaint. But if there is some ambiguity there going forward, or if that needs to be corrected, whether it's that paragraph or anything else in terms of the allegations, if an amendment is deemed appropriate, I would request permission to do so. Again, I don't believe that any amendment is necessary because the complaint consistently alleges a single agreement that was formed in March of 2011. And to jump a little forward here and combine these arguments a bit in terms of the writing, it was formed in March of 2011, as I indicated. The documentation, and as I cited in the brief, there are more than one writings reflecting the agreement that was made between the parties here. including a territory map that the parties filled out themselves, created the territories that they agreed upon, and it had handwritten notations on there by Basement Systems in terms of whose territory was whose and how that was to be divided. And then we've got the November 8th email that I understand the arguments that are being made, but certainly for purposes of a C8 motion, more than adequate allegations have been made that a written contract exists in sufficient form to satisfy the statute of frauds. Now, maybe we have some arguments over the scope of the territory, uh, but there's in the timing of things, but those are issues of fact. And as I cited in the brief, the duration under Michigan law is not an essential element to the formation of a contract. In the complaint, the allegation is made that the non-compete remained for a reasonable time after one of the two dealers left the network. Again, that's in the complaint and is certainly more than adequate in terms of the allegations to survive a motion under C8. Now, there may be disputes over what is reasonable and so forth, but for purposes of this motion, the allegations are sufficient to survive a motion on those grounds. With regard to the timing and the execution of the agreement, I do want to supplement one argument that was made, and that was the argument that the map and the email by FSM is a sufficient writing on the statute of frauds by the party to be charged. I made the argument, but I did not cite to the Uniform Electronic Transactions Act, which provides that it says if subpart 3, if a law requires a record to be in writing, an electronic record satisfies the law. So Michigan law plainly provides that the documentation, particularly the email by FSM, is certainly satisfactory in terms of the author of the email is Mr. Genord, who is he said he's the president on the email for FSM. That is certainly, again, sufficient for a motion under C8 to survive that motion by the allegations that the writing, the November 8, 2017 email is an adequate writing to satisfy the statute of frauds under Michigan law. On the last part about the antitrust claims and the adequacy of a writing, it was cited in the brief, the innovation ventures versus liquid manufacturing. The Michigan Supreme Court, consistently with what the Sixth Circuit has decided, and that is there is a presumption in favor of the rule of reason unless there is a plain categorization of the agreement within a per se illegal contract. We don't have that here when you have at least indicia of the agreement being a vertical agreement, and the Michigan Supreme Court clearly laid out and cites additional authority that the rule of reason is to be used when evaluating commercial non-compete agreements. So again, as I argued in the response brief, that there is a presumption for the rule of reason, and that's further reinforced by the Michigan Supreme Court in the innovation ventures case I cited in the response. And then as to the remainder of the claims, again, as I stated in the brief, C8, the allegations are adequate in those claims to survive a motion under C8. Again, may have factual issues of fact as to whether or not those claims have merit at the end of the day, but at least for today's purposes, the allegations are adequate in that regard. And then finally, as it relates to Cortec versus Groundworks Operations LLC, Certainly, as I stated in the response, that's appropriate for an amendment. At the time the amended complaint was filed, I did make an effort to confirm the defendant, the party that acquired FSM, and it appears to be a conglomeration of private equity. I made the best effort based on the information that I had available to identify what appears to be a private equity fund and some indication it was doing business under Groundworks. Now I see that Groundworks Operations LLC, from the couple pages that were provided, was the acquirer, and already in the complaint there's allegations of successor liability within the complaint that warrant any successor to FSM being equally responsible for the non-compete agreement as much as FSM is. Thank you, Your Honor.
Thank you. And Mr. Peralta, did you want some rebuttal time?
Yes, Your Honor. Just for a few minutes, just to address a couple of points. I think counsel, if I heard his argument correctly, he said that the complaint was consistently alleges a single contract, and unfortunately that is not correct. I think in paragraph 15 of the complaint, there's actually a revealing allegation. It says, quote, "The non-compete agreement was ancillary to and separate from the network dealer agreements of Ayers Basement and FSM with Basement Systems." We view that as an acknowledgement of what the actual agreement was, which that is attempted to be enforced here, which is a horizontal, per se, illegal agreement to restrict competition. I think that's the first point. The second point, I think that is being unfortunately glossed over here, is that the email on which they so heavily rely here lacks any reference to fundamental terms of the contract. Again, we get back to this issue of an indefinite term, and there's nothing in the email. The email only refers to an agreement. It doesn't contain the necessary terms of the agreement. We understand it's not required to contain all of the terms, Your Honor, under jurisprudence under your statute of frauds, but there's no writing that contains anything with respect to duration. I think counsel's misguided when he says that the allegations in the complaint can effectively serve as the writing. Well, the writing has to be a writing from the parties or exchanged between the parties or acknowledged or adopted by the parties. But there's no such writing between the parties that reflects anything with respect to duration. I think these multiple lack of key terms is exactly why this complaint should be dismissed. Not only because it's the one and only complaint that we've seen, or for that matter, in a case law that has recognized this so-called verbal or oral non-compete, but it also goes to the issue of why the court has to have these very terms to begin with. If we accept for a moment counsel's argument that this type of agreement has to be assessed under the rule of reason, then the challenge for the court is, where are the essential terms by which that analysis is to take place? What is that scope? And there's nothing in the allegations that tells us where the scope is. In fact, the allegations show that there was no meeting of the minds as to what that scope is. There was no meeting of the minds with respect to anything with respect to duration. And those are essential elements of any contract. And as we know, these types of agreements are carefully and strictly scrutinized for that very purpose, because these are by their nature restraints in trade. And finally, Your Honor, I would point to the innovations case that counsel cites to us, and I think highlighted for the court's consideration. Innovation is an interesting case, only because it is a non-compete, but it's a vertical non-compete. It's not between two competitors. It's between a customer and an equipment manufacturer. So there is a clear distinction there, and each and every one of the authorities that Ayers cites for us to argue verticality, to argue the rule of reason. All of them had written agreements. Again, we lack that, and by the allegations in the complaint, that deficiency is fatal to their claims. And so, Your Honor, I will stop right there because I think I've addressed Mr. Matheson's key arguments. We don't believe that this is subject to amendment. Any amendment at this point would be futile, because when there's no writing, there is no writing, and an amendment without more there is no further cure for that, what we believe to be a fatal deficiency in this claim and the series of claims that flow from the breach of contract claim. Thank you.
Thank you. Okay, first of all, I'll put aside the C10 portion until the end of this, but as to FSM, this is a C8 motion. So for purposes of a C8 motion, I take all the well-pled allegations in the complaint as true, and assess whether the complaint fails as a matter of law. Count 1 of the first amended complaint alleges a breach of contract. And the allegations are, and I think it is important because for this motion, as I said, all the allegations are taken as true. So the allegations are as follows: that Basement Systems, which is or is, I guess, a distributor of sorts in this case, or not a party in this case, but a distributor as the role it's played in this case, and Ayers Basement and FSM entered into a non-compete agreement. And it alleges that the defendant, FSM, has breached that agreement. The First Amendment complaint further alleges that Ayers and FSM are dealers that install, service, and repair basement waterproofing systems, as well as some other similar services that are described. At one time, both those dealers, Ayers and FSM, were members of the Basement Systems network. And as dealers in the network, they both enjoyed access to preferred pricing on equipment and products, leadership and sales training, industry-specific software, and website management. It's also alleged that in March of 2011, the three companies, that is Basement Systems and the two dealers, Ayers and FSM, entered into an oral agreement that assigned exclusive geographic territories each to Ayers and FSM. The non-compete agreement, the oral agreement, was implemented by Basement Systems by assigning independently generated sales leads to either Ayers or FSM based on their assigned territory. The agreement was to continue during the time that Ayers and FSM were in the network, or for a reasonable amount of time thereafter. There was no price fixing involved, and the First Amendment complaint says the non-compete was intended to ensure high levels of service in installing Basement Systems products and to protect Basement Systems, Ayers, and FSM's goodwill in their relevant competitive marketplaces. And then finally, the First Amendment complaint alleges that in December of 2019, FSM left the Basement Systems network and began competing against Ayers in Ayers' assigned territory and in breach of the non-compete agreement. I'll put aside for a moment the issues that are raised by the defendants about the oral agreement and the statute of frauds and the meeting of the minds issue. And I'll address first FSM's claim that the non-compete agreement is an illegal restraint on competition in violation of antitrust laws, and it can't be enforced. Because if that is true, then as counsel has indicated, the other issues are moot. So everyone agrees that federal law decided under the Sherman Act applies. And under federal law, first and foremost, the most important issue is whether this is indeed a case where the per se rule would apply, or is it a case where the rule of reason should apply. If the per se rule applies, this non-compete would be deemed illegal as a matter of law. If the rule of reason applies, the case would proceed and it would require a very fact-intensive inquiry into whether there were legitimate competitive reasons or interests behind the non-compete agreement. The plaintiff makes a number of arguments in that regard. I want to address, though, first the plaintiff's claim that Innovation Ventures, that's the Michigan Supreme Court case, tells us that when it comes to non-competes between businesses, we have to apply the rule of reason. I disagree with that as a conclusion from the Innovation Ventures case. First of all, the case is rather complicated factually as to who these businesses are and what they do and what their relationship is to each other. But I don't see any analysis in that case where they actually talk about whether it's disputed that it's a vertical or a horizontal arrangement or relationship. It seems like they take it for a given that it's a vertical relationship. I mean, I'm not sure if it is or is not, but it wasn't an issue in the case and it wasn't a ruling in the case. So when they say that in general, federal courts have assessed non-compete agreements between two commercial entities under the rule of reason, I can't conclude from that that they're basically going against federal law and saying that even if you have a horizontal relationship, you use the rule of reason, or that you always use the rule of reason as between two businesses in a non-compete situation. They rely on federal law, and they're not violating federal law, so I just don't think we can get anything out of this case other than whether they were vertical or horizontal was not in dispute, and the Supreme Court applied the rule of reason consistent with the federal law. The federal law is in multiple cases, of course, that have been cited by the parties. The one that I found the most informative, laying out exactly what the issue is and how to analyze it, is U.S. versus Topco Associates, TOPCO. That was the U.S. Supreme Court, where they explained that certain business relationships are per se violations of the Act without regard to a consideration of their reasonableness. The court explained it very well, for me anyway, in this way. One of the classic examples of a per se violation is an agreement between competitors at the same level of the market structure to allocate territories in order to minimize competition. Such concerted action is usually termed a horizontal restraint, in contradistinction to combinations of persons at different levels of the market structure, like manufacturers and distributors, which are termed vertical restraints. This court has reiterated time and time again that horizontal territorial limitations are naked restraints of trade with no purpose except stifling of competition. So the plaintiff in this case has argued that this case involves a vertical restraint because the agreement as it was made includes the distributor, Basement Systems, and the dealers, Ayers and FSM, representing different levels of the market structure. I think that would at least arguably be true and probably would get plaintiff past a per se violation if FSM was still in the network. The problem is that FSM is no longer in the network. Further, once FSM is no longer in the network, the very factors as alleged in the first amended complaint that would go toward bringing this under the rule of reason and perhaps an ultimate finding that it is a reasonable restraint on trade would no longer exist. The restraint no longer provides benefits within a dealer distribution chain. Basement Systems is no longer providing sales leads to FSM, and FSM is no longer getting preferred pricing on Basement Systems products. Those are the very factors that go into making a vertical restraint of trade a reasonable restraint of trade. Such a vertical restraint of trade, as the courts have noted, do restrain trade, but they do it for justified, valid, competitive business interests. And, that, again, that would be the analysis or the conclusion that would be drawn way down at the end of the line if this were subject to the rule of reason. But none of that can be said about the rule of reason or legitimate business interests justifying a restraint on trade when it is when those factors no longer apply and it's a horizontal restraint on trade. It can no longer be said that the restraint is not intended to stifle competition. Take away the factors that justified it in the first place, which you do when FSM leaves the network, and you've got nothing but an agreement to stifle competition. So just to be clear, Basement Systems is not a party to this case, and FSM is no longer in the network. I really think that even if Basement Systems was a party to this case, it wouldn't even matter because it's still a division of territories between two competitors that are on the same level in the market that is trying to be enforced here, with FSM no longer in the network. But in any event, Basement Systems isn't a party to this case. FSM is no longer in the network. This is Ayers, a dealer in the network, trying to enforce the non-compete against FSM, a former dealer in the network, but no more a competitor on an equal level with Ayers. And Ayers and FSM are competitors not only at the same level of market structure, but Ayers is attempting to enforce against FSM a territorial restriction. So in the words of the Supreme Court, such a horizontal territorial limitation is a naked restraint of trade with no purpose except stifling of competition. And again, I don't think it makes any difference that the original agreement could arguably and probably could be called a vertical type of an arrangement. The agreement to be enforced is competitors at the same level of the market structure. It's illegal, and the non-compete agreement in this case cannot be enforced against FSM. And that renders all the remaining issues about the oral contract, meeting of the minds, statute of frauds, all of that moot. I would also grant the C10 portion of the motion as Quartet Group Fund 5 was erroneously believed based on limited information that was only available at the time to be a successor to FSM. Obviously, the request to amend the complaint would be futile again for the reasons that I've already stated. It's an unenforceable, illegal restraint of trade contract. So for all of the above reasons, I'm granting the defendant's motion for summary disposition under C8 as to Foundation Systems of Michigan, Inc., and under C10 as to Quartet Group Fund 7. And Mr. Gordon, since you're local, you want to submit an order? I think you said yes, you're muted,
I
but
will,
I
Your
think
Honor.
I could read lips.
Thank you,
Okay,
Your
I'll
Honor.
look for it. I'll look for it then. Thank you.
Thank you, Your Honor. Have a good
Thank you, Your
afternoon.
Honor.
Good afternoon.
Hi, I'm just trying to figure out who all I need to let in here from the meeting or the waiting room.
I'm the only one for the defendant.
Okay, and then I think we've got two of you for the plaintiff, Ms. Marinelli.
Good. Oh. Good afternoon, Your Honor. Sorry about the delay.
No, I'm sorry, I've been doing the hearing ahead of you. The confusing thing here in my waiting room is that the next case after this one is a Miller Canfield case also, but you three are the only three on this one, right?
Correct, yes.
Okay. All right, this is BBC Technologies LLC versus Raywall Agrotech Foods Limited, docket number 19-873CB. And there are two motions this afternoon. The plaintiff's motion to amend the complaint is first, and then we've got the plaintiff's motion to compel. Could I have your appearances first, though, for the record?
Sure. Joseph Vernon for plaintiff, BBC.
Alan Nyholt for defendant Raywall.
Anita Marinelli for plaintiff, BBC.
Okay. And then who's arguing this for plaintiff? Mr. Vernon, you?
Yes, Your Honor.
Okay, go ahead.
Thank you. And just by way of very brief background, our client BBC provided these 5 large fruit sorting machines to Raywall, and Raywall agreed to pay the $129,000 a year. We delivered the machines in 2017. There was a 1-week delay in the delivery of one of the machines and some issues setting it up. So the parties talked about how are we going to resolve this. They agreed to resolve it for a $49,000 credit, and then things were fine. And the counterclaim that was filed here is the first that we've heard Raywall complain about anything that occurred in 2018. There are documents to support these claims, and what they say doesn't quite add up. But what's critical is that there were a number of conversations between BBC and Raywall in 2018 and 2019, so after these issues supposedly arose, in which Raywall promised to make the outstanding payments. So that's what prompted us to file suit. And regarding the motion to compel, so we've asked them for documents relating to the defenses and counterclaims, including, primarily internal communications and documentations about this credit, because they're suggesting now that it was a conditional credit, and documents relating to all the conversations that we had when they promised to make the payments. And they haven't produced any internal conversations. In the initial disclosures, they've identified 7 employees who have knowledge of the issues in this case. BBC communicated with at least 2 of those individuals interchangeably, primarily via email, but sometimes via phone. So I find it hard to believe that there are no internal communications. The supplemental Exhibit F that we forwarded today was just an example of internal communications that they did have. And one of the gentlemen with whom BBC spoke most frequently, who's no longer with Raywall, has discussed that there were communications and has said so. So I've worked with Mr. Nyholt to resolve this, and I want to be clear, discovery motions are not something that I love or that the court loves, and Mr. Nyholt has been working with me. I believe that part of the concern, his client is in British Columbia, Canada, and they have a Canadian counsel as well. But what Mr. Nyholt has represented to me is that he's asked them to comply with this request, but there are no internal emails. Like what we're asking for essentially is an order from the court, and I understand that Mr. Nyholt has asked, and they're claiming that none exist. We strongly believe that there are some, and we'd ask at least for the court to enter an order that essentially incorporates, so Mr. Nyholt did produce financial documents in response to our request, so that part of the motion to compel is resolved. But in our requested relief, we have items A, C, and D And also, I guess I would just add the catch-all that they produced responsive documents in their possession, including internal documents, within a time frame that the court deems appropriate. And I'm hopeful that with a court order, there will be cooperation. And if not, then there's the certification that there are no other documents. But that's what we propose to resolve that motion.
Okay. I actually was on the motion to amend the complaint, but that's all right. Mr.
I'm sorry.
Nyholt? That's all right. It doesn't
Yeah.
matter what order to amend. Mr. Nyholt?
Yes, I mean, Your Honor, as brother counsel pointed out, the clients have looked for these internal emails. They don't exist. And they have, they're willing to certify in writing that they don't exist. We can't produce something that doesn't exist. So that's where we stand on it. I don't think, in order that they provide appropriate certification. We've had some delays in getting response from that. They're in British Columbia. There's been some, illnesses there, and there's been some shutdowns, and it's made getting response to that have been somewhat difficult, particularly in the last few weeks. So, with respect to that, I mean, I'm not sure how we can have an order telling us to produce something they've already said they don't have. So, I'm not sure what we're accomplishing here, but I mean, if you want to give us a specific order that says produce the things that we've already said don't exist, we could respond to that in kind. But I'm not seeing much sense here.
Yeah, I don't really see entering an order to compel, ordering someone to produce what they've said they don't have. I think that the plaintiff is entitled, though, to some written documentation that your client says they don't have anything else. So if you would provide that, I will not grant a motion to compel.
Yep, absolutely. That's no problem at all.
Okay,
And
let's do the motion. I'm sorry?
I was just going to ask, would that be a certification from client or just, because what we have so far is the email from counsel?
Yeah.
Well, I think,
Okay.
yeah.
I didn't mean to cut you off, Your Honor. I mean, yes, this is kind of coming together with the wings are coming on while the plane's in motion on this one. So we do have only an email at this point, but yes, I can give something a little bit more formal to that effect. I think that would be appropriate to have the client sign off directly on that. So there's, none of the telephone that comes from they tell me and then I tell him, and I'll make sure that they're on record for that as well. And that's completely acceptable to me.
Okay, you're satisfied, Mr. Vernon, with that?
Yes, Your Honor.
Okay, then your motion to amend the complaint.
Okay, so and in reviewing the response, I think there's a bit of a misunderstanding, which is on me for some inartful drafting. We're not alleging new facts. We're claiming new types of damages. And under Sherrard, we think we should be allowed to do that at this stage. And the reason that we initially thought necessary for this is in our complaint, it's arguably styled in a way that suggests that we're seeking only $144,000. And that number incorporates a credit that we gave them for the issues that are now, part of their counterclaim. So what the intention was to make clear was that we're seeking everything we're owed under the contract. So if for some reason, and we still maintain that the credit was valid and that these other issues don't exist or aren't an issue, but if for some reason the credit is not deemed to be, there isn't the consideration and it's not valid, then we're seeking everything that we're owed. In addition to sort of compensatory and consequential damages, and those are available on equipment lease cases. Now, we've tried to specify, to be more specific, so it's not just this vague compensatory and consequential, by explaining that what we're seeking includes the lost rental value from the machines that we would have otherwise possessed. And it's not, I understand the argument that a portion of that could be double dipping, but our contract from BBC's standpoint does not limit consequential or compensatory damages. And we argue that they're foreseeable in regards to the consequential, and this is akin to sort of lost profits. It's an additional element of damages that we're claiming as part of our claim. And the issue is when Raywall has the machines, they're tied up for a year. They're paying for the 3 or 4 months that they're using them. But if Raywall did not have the machines for those additional months, we could have used them otherwise. So it's an additional damage theory, and just making clear that if to any extent that the credit is deemed not valid or there wasn't consideration, that we're seeking the full amount that we're owed under the contract plus the interest. On the fraud claim, I believe that we're entitled to plead arguably inconsistent theories in a case. And in response to our complaint, Mr. Nyholt's client has said that the contract doesn't exist, or that there was a new contract entered into later on, which we say isn't the case. So to some degrees, that second count is sort of belt and suspenders. But at this stage, based on the allegations and the promises that payment would be made and that we relied on, we think they're at least viable claims. There aren't new facts. They are just new damages theories. And at a summary judgment stage, sorry.
Mr. Byrne, I got to stop you because I thought your motion was really misleading in that regard, because you said that same thing a couple times over in your motion. No new facts, just different damages. So then I looked at your original complaint and your proposed amended one, and isn't there a whole new count for fraudulent misrepresentation?
But the elements of the count are that they promised to make a payment to us, and that we didn't return the machine based on that promise, and they never intended to fulfill that promise. So it's the same allegations. We haven't changed anything in the factual counts. And their claim is that there was no...
Sorry, when you add a count for a whole new claim of fraudulent misrepresentation and tell the court that you aren't adding anything new except different damages, I think that's very misleading. But tell me how you have statutory authorization for punitive damages.
That would have been part of the, I believe that's part of the fraudulent count. There is it was KCV Auto Owners that talks about exemplary damages being allowed where the elements of fraud are, sorry, the language is a little, elements of fraud and malice are wanton and reckless disregard of a party's rights. And our allegation is that they never intended to make these payments that caused us to leave the machines there for an extra year. So I guess what I would ask for is if we can't plead the alternate fraud theory, which seems to be the most problematic with the proposed amendment, that at least we be able to clarify that in the contracts claim, we're seeking everything that we're owed under the contract. So all of the amendments, perhaps except for that second count, if that is the most objectionable aspect. I'm sorry.
All right, go ahead, Mr. Nyholt.
Yeah, I think there's some confusion about what we're talking about, because when I hear the document explained, I hear different documents. I heard Mr. Vernon mention exemplary damages. What he's asked for in the complaint are punitive damages, and those types of damages in Michigan law are not interchangeable. Exemplary damages are additional compensation for your for malicious violations of your rights, whereas punitive damages are sought to actually punish you for a violation. What they pled is punitive damages. I mean, it sounds like in Mr. Vernon's mind, he's kind of got the two concepts interwoven, but we can't, in our system of notice pleading, we look at what it says in the pleadings, and in the pleadings, it asks for punitive damages, which are not allowable. Number two, in respect of there's some clarification. I mean, we need to see the proposed amended complaint fails in several respects. I mean, not just with the punitive damages, there's also the issue of double recovery, because as the thing is pled, he's asking us to pay him both for the unpaid rental payments that they promised to pay, and also to pay lost rental value that they could have got from renting the machines to somebody else. So basically, they're getting paid two different rental payments, which is also contrary to Michigan law, because it's double recovery. Plus, at its heart, this whole fraudulent theory, I mean, on the beginning, Michigan law has said, pretty concisely that a plaintiff cannot maintain an action in tort for non-performance of a contract. And there must be a separate distinct duty imposed by law. And basically what he's saying is that I'm not reading sufficient allegations in this to give us a separate duty apart from the contract between the parties for the lease. So I think, that it's very well established that a motion to amend fails for futility when the proposed amendment on its face lacks legal sufficiency. And I think that's the case here.
All right, thank you. I am just hugely skeptical of this claim for fraudulent misrepresentation, and not for the reason actually that the defendant has said, because I don't think it falls under the rule that you can't bring a tort for non-performance of a contract. Because if it's fraudulent misrepresentation, that can stand on its own. That's a tort even if the parties never had any contractual relationship between them whatsoever. But I'm hugely skeptical because you can't base fraud on a promise of future conduct. And that is generally applied to, I'll pay you next week, I'll pay you next month. There is an exception, and I recognize that, but it is an exception for when a promise is made in bad faith without the intent to perform it at the time that it's made. You have to have, in order to meet that exception, you have to have evidence of some conduct around the time that the representation was made that would show, and remember this is fraud, by clear and convincing evidence that there was no intent to make the payment. So, futility is judged like a C8 motion, and the complaint alleges what it needs to allege for fraudulent misrepresentation. I would just caution counsel that you better have the facts to back it up, because you could be subject to sanctions if you don't, because that's a tough one to prove on these facts. But it meets it states a cause of action for fraudulent misrepresentation, and I will allow the amendment of that to add that count. Punitive damages, counsel has not shown to me any statutory authorization for punitive damages. They are very, very restricted in civil law. And as far as the lost rental value, I understand the argument of how it sounds like a double recovery. I'll consider it as, I'll just say, let's put it this way. The plaintiff won't be able to get any double recovery. Perhaps we could view these as alternatives. What one covers, if one doesn't cover something and the other one does, then the plaintiff is covered that way. But in the end, there won't be any double recovery. But I think he can still put that request in there for those damages. And that's the rental damages I'm talking about, not the punitive damages. Those have to be stricken. But other than that, I'll allow the amendment.
Thank you, Your Honor.
Thank you.
All right, someone needs to do an order then and submit it.
Okay, Mr. Nyhold and I will put that together.
Okay,
Absolutely.
thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Trying to figure out who all in my waiting room is on this case. Someone with a Miller Canfield email address, that must be this case.
Yes, Your Honor. Erica Drew from my office is waiting to join.
Okay, got her. Okay, looks like everybody's connected. Sorry for the delay, everyone. My hearings before this went a little longer than I thought they would. This is Sanitation Strategies LLC versus Livingston and Rochester Midland Corporation, docket number 19-803CB. And this is the time set for hearing on the plaintiff's motion to modify the laptop protocol, compel discovery for a protective order, and to modify the scheduling order. If I got all that, and then before we go on, if you would all state your appearances for the record, starting with the plaintiff, please.
Scott Carvo on behalf of Sanitation Strategies.
Good afternoon, Your Honor. Scott Eldridge on behalf of the defendants.
And good afternoon, Your Honor. Erica Drew, also on behalf of the defendants.
Thank you. Mr. Carvo, you may go ahead.
Thank you, Your Honor. And I want to apologize for the filing. I'll handle this in any order that you would like. But unfortunately, I picked this file up whole cloth about 2 weeks ago because of some health issues that Mr. Pacific endured. And the resulting motion practice, I think, is related to that in several ways. So I filed the motion, though, because I have not had the pleasure of appearing before Your Honor before. And I did not know what your practice was with respect to discovery motions and your discovery deadline. So this is the last Wednesday or hearing date before November 3rd, which is the current scheduled date. That's why I filed the motion in this way. I did attempt to work these issues out in advance with Mr. Eldridge by calling him and emailing him. We were unable to do so. So I'm happy to handle these in whatever order you want, but I think it makes sense to start with Mr. Fannin and his report, because this is a case about alleged theft of confidential information from my client. And throughout this case, we've seen affidavits submitted by Mr. Livingston repeatedly saying that he didn't have these, and quote, I didn't ever have, or doesn't remember ever having possessed those particular flash drives. Sorry, the quote starts with ever, having possessed those particular flash drives or information, if any, that may have been on those flash drives. And so for the majority of the discovery in this case, we've been proceeding with Mr. Livingston's representations and trying to find out if they're actually accurate. What Mr. Fannin's report shows is that they are not. That 6 days before the entry of the temporary restraining order and 20 days before his first sworn affidavit, he connected these flash drives to his RMC laptop 3 times. It also shows that he has accessed the current customer folder, which were within a Sanitation Strategies domain or folder structure. And that he, in total, was accessing those flash drives 19 different times and frequently accessing our files. And so that discovery does change things. It changes what happens at his depth. It changes what happens with all of the depths that occur after that, because everyone in this case, including my client, has the right to know what was taken from him. And we have the right to examine Mr. Livingston and corporate representatives from RMC about what was taken and how it may have been used. And so that's what we're trying to do here. And this isn't a surprise to Mr. Eldridge, because during the scheduling of this, the schedule was contemplated this very fact. Mr. Fannin's dep was scheduled first, and the remaining fact witnesses were scheduled after. I think the intention being, we have to see what he finds here. Now, in the course of his review, he found a 4th flash drive, which we previously did not know about, which he can, again, as you can see in the exhibit that we attached, can say he had while he was at Sanitation Strategies, and he used or plugged in while he was at RMC. We need to know what was on that 4th flash drive, obviously. It goes to the heart of this case and what this case has been about since inception, which is the theft of confidential information. So we're asking the court to allow him to fully articulate what he found in terms of what was taken from Sanitation Strategies by going through that 4th flash drive, and then by rescheduling these depositions and pushing discovery back 60 days, because as Mr. Eldridge acknowledged last night, he's got some things that he wants. He would like us to produce the files that were on those flash drives in tabs 1 and 2 of Mr. Fannin's report as they exist currently. I have no problem with that. We just were able to de-designate those tabs as attorney's eyes only last week. I just was able to share this information with my client last week. And so, of course, we're going to get those materials together and produce them. He's got every right to see them, just as I have every right to see what RMC created when they were using these documents on their end. And that kind of gets to extending the discovery window, rescheduling the depositions and the motions to compel. But really, all this is, Judge, is about hiding the ball. They've tried to hide the ball from the inception of litigation. What Mr. Fannon's report makes clear is that he did take and access this information. And now we need to figure out the extent and scope of that. And so there's two quick requests for produce that were mentioned here. And I think they're illustrative here. One is about Virginia Tech, a client or customer of RMC that we know RMC, or excuse me, of Sanitation Strategies that we know RMC solicited. We know that he's accessed files related to that. We haven't seen a lot of materials about what was developed after that. When you look at those other requests, de-designation of the Brown University materials and the NIH school, we have seen scant materials, including presentations that Mr. Livingston was using while at RMC. We saw a 2019 sales presentation. We have not seen any of the predecessors. We have not seen what he was using in 2018. We have not seen what he was using in 2017. And we now know that he was regularly accessing our information in 2016. So we have every right to see those things, Your Honor. And but for the unfortunate health incident that occurred here, and I'll mention that Mr. Pacific is unable to continue on this file. So all future appearances will be made by someone other than him. Probably likely in most situations it will be me. So if that had not happened, Mr. Fannon's deposition would have occurred. There likely would have been motion practice about his order, or about his report, excuse me, and we would have had that decided before the depositions. So that's all we're asking for here, Judge, is to proceed with discovery in the way that spine specialists contemplates, which is to promote the discovery of the true facts and circumstances of a controversy, rather than aid in their concealment. And every single one of the arguments I see in opposition to this is about aiding concealment, not about discovering facts.
Thank you. Mr. Eldridge?
Thank you, Your Honor, and may it please the court. There's a lot to unpack here, Your Honor, and I might want to do it in a little bit more orderly fashion in terms of responding to counsel's presentation. First, at the outset, there's a couple of maybe housekeeping items before I address the arguments in more substance, and that is the plaintiff filed the instant motion and the entire set of exhibits purportedly under seal without seeking any leave of the court, which is not permissible, and so I'm not sure how we should be addressing that piece of it. There's a protocol that normally has to be followed when filing material even marked confidential per a protective order under seal. They didn't follow it. They also attempted to file an improper reply brief late afternoon, again without seeking leave of the court. There's nothing in the court rules that permits them to file a reply brief. That they've not followed those court rules, I guess, doesn't come to a whole lot of so much surprise to us, given that they now are asking the court to reward the plaintiff with yet another discovery request. This is their second time asking for discovery. Despite having, without doubt, violated this court's September 21 order detailing how that limited forensic examination was going to occur of that RMC laptop. Essentially now embarking on the very fishing expedition that we opposed when negotiating the terms of that stipulated order, based on plaintiff's counsel's representations to me that it would indeed be a limited review. Had we known that they were going to go beyond the plain language of this court's order and start snooping around for additional devices that were attached to the RMC laptop, we would have never agreed to that stipulated order. Instead, we agreed to a stipulated order that called for a review of only whether 3 previously identified flash drives had been attached to that laptop. They ignored that order, your order, and decided to go looking for other devices and now claim that they've found a 4th USB flash drive that was attached to it. Apparently they couldn't help themselves, Your Honor, demonstrating clearly their ability or willingness to flout your orders. So we don't have any confidence that if you end up entering an order today that they're asking you to enter, that they'll follow that one, leading to further fishing around that the case law that we cited in our briefing says is improper. These flash drives that have been addressed in the Fannin report, and that to which Mr. Carvo has alluded today. No one knows where they are, except the first one that was turned over back at the end of last year in response to the temporary restraining order. Mr. Livingston doesn't have them. He hasn't made any misrepresentation about whether he possesses them. He didn't possess them when he signed his affidavit. He doesn't possess them now. This was back in the end of last year. And we question, and so what I understand their request vis-a-vis Mr. Fannin's examination of the laptop to be, is that they want to somehow reveal whatever he claims to have found and utilize whatever he claims to have found in that when he violated your court order. And we question the utility of that. And we question whether, and we disagree that it's proportionate to the needs of the case. And and for that reason, it wouldn't be even discoverable. A couple of points to make, Your Honor, in that regard and why it's not proportional to the needs of the case. What Mr. Fannin's report, the limited portion that we agreed to, or that he did follow when he followed your order, was he made a determination whether 3 other flash drives, the 3 that the parties previously were aware of that actually existed, had been plugged in at some point in time to the RMC laptop. His report reveals that they were, and that certain files purported to be sanitation strategies files were accessed on that laptop. That's it. That's all it says. Doesn't say whether they were transferred, doesn't say whether files were copied, doesn't say whether files were used, only that they were accessed. And now now those files and those flash drives are not in defendant's possession at all and haven't been since end of last year. And so we question the utility of what the information they hope to glean is going to provide in this case. Because ultimately the simple fact that a flash drive was inserted into a laptop doesn't tell us anything about whether it was confidential, doesn't tell us anything about whether that information was used, or whether that the plaintiffs were harmed in any way by it. All supposition to reach those sorts of big leaps and conclusions. But more important, or maybe not more important, Your Honor, but equally as important, is this last Monday we had an opportunity to depose the Vice President of Sales and Customer Service at Sanitation Strategies. And we asked him point blank whether he's aware of any facts to suggest that Troy Livingston or anyone else at RMC has ever shared confidential information of sanitation strategies with anyone, and he emphatically said he was not aware of any such circumstances or any facts, including with respect to the 3 clients that they claim RMC stole and have identified in their first amended complaint. And so he's effectively admitted that that they're not aware of any information that has been used improperly to harm sanitation strategies. So I'm not sure what the utility is if we see what is on a 4th flash drive based on Mr. Fannin's representations. Furthermore, also I think relevant to this issue of whether it's proportionate to the needs of the case is that, again, Mr. Livingston doesn't have these flash drives anymore with these sanitation strategies files on them. And so if they were so valuable from a competitive standpoint, it doesn't make sense that he would discard them, which he's done, clearly. He doesn't have them. And so for those reasons, Your Honor, and primarily because we don't think that you should be rewarding the plaintiff for having blatantly violated your order and now coming to you after the fact saying, oh, we need to modify it, Your Honor. We don't think that it's proportional to the needs of the case to further extend discovery for that reason. Regarding the motion to compel, Mr. Carvo in his motion has suggested that you should order us to compel marketing plan material and email communication material that just doesn't exist. I can't produce something on behalf of my client that my client tells me it does not have or that does not exist. And so I don't know how we resolve that other than with a denial of that motion, Your Honor. In the briefing, they suggest that somehow we're supposed to be explaining to them why those materials don't exist. Well, they haven't asked us in writing through any discovery request why those materials no longer exist. But they're free to ask those questions during depositions. They're absolutely free to ask those questions during depositions. So to suggest that somehow we're withholding information in that regard is simply not true. Regarding the extension of discovery, Your Honor, we just don't think it's necessary. We have depositions lined up between now and the end of the discovery period, November 3rd on Tuesday. We're lined up to take Mr. McDonald's deposition tomorrow and prepared to do so. We're taking Mr. Streeter's deposition on Friday. And plaintiffs asked us to hold the 2nd and the 3rd for depositions of 4 RMC individuals, which we have done, and we're planning to make them available for their depositions on a last-minute basis. And we're taking Mr. Fannon's deposition on Tuesday. The reason we're jammed up to the end of, or against the end of the discovery deadline, Your Honor, has nothing to do with RMC. This is because after they asked for additional discovery from you months ago, back in July, you gave them 60 days and then they sat around. We've been asking to schedule depositions since June. And we only got actual dep notices to depose RMC employees not until Friday afternoon of this last week. First time in the whole case we got deposition notices. And they were to cram them in on the second to last and the very last day of discovery. So they've already had a full-blown discovery period, the first 6 months that you gave us during the scheduling order. And then you gave them an additional 60 days. And for whatever reason now, it's not enough for them. And I think what's happening, Your Honor, is because they're not revealing and discovering any facts or evidence or materials to actually prove their case. Your Honor, you remember back in when we were arguing in front of you about their motion to amend their complaint to include a conversion claim. Judge, it's less than a week before the end of discovery, and we still have not been told what material or property it is that they claim was converted. We still don't know because they haven't answered those questions. And now they don't want to answer those questions during depositions because they want, for some reason, a protective order to avoid their depositions, and I'm not sure why. This 4th USB issue doesn't impact our ability to depose Mr. McDonald tomorrow or Mr. Streeter on Friday. Yet they want a protective order to avoid all depositions for some reason and ask for an additional 60 days, which we think is just wholly unnecessary, only designed to further fish around for the information that they haven't been able to uncover to support their claims to date, Your Honor. Last, regarding the Brown University records and their request to de-designate them as attorney's eyes only. The Brown University, what they did, Your Honor, is they went out and they subpoenaed all communications between RMC and other records between RMC and Brown University, which has been a long-time RMC client, spanning a period of 7 years. Brown University has never been a sanitation strategies client. So now they're just randomly selecting RMC clients to subpoena records to try and glean some competitive advantage as to how it is that RMC operates its business and deals with its relationships with its clients over a long-term basis. This is not a customer or potential customer that Sanitation Strategies has identified as being stolen from them by RMC. Again, they've never been a Sanitation Strategies client. Yet they want 7 years worth of our records and communications with our client so that they can go and compete and understand how it is that we service clients over a long-term period and for no other reason. And so we mark them as attorney's eyes only. And now they want us to de-designate them so that Mr. McDonald, the owner of Sanitation Strategies, can look at them and see how it is that RMC services its clients. But our designation of that material as AEO, which we believe is wholly appropriate under the circumstances, doesn't prohibit plaintiff from asking our client representatives about it during their depositions. It just means that Sanitation Strategies personnel can't be in on the deposition during that period of it. So there's no need to at this juncture to de-designate those materials from the AEO designation. Your Honor, We also addressed all of these issues in our brief, and I think we did so sufficiently. I'm happy to answer any questions that you have at this point. Otherwise, I'll yield the podium.
I don't have any for you. I'll give you, Mr. Carbo, some rebuttal time, but let me ask you first. We don't have paper files at the court anymore, so I wasn't aware. Did you file all your attachments under seal?
Yes, Your Honor. The issue with the de-designation, because the attorney's eye is only on the Brown University documents, meant that we did file it all under seal. We didn't have time to separately file motions just because of the truncated nature of my involvement in the file. So we did file that under seal just to make sure that we had everything heard, because there was an AEO designation and because we were going to be talking about a piece of Mr. Fannon's findings that had not previously been reported on yet. So I wanted to make sure that we, out of an abundance of caution being new to the file, that I didn't step on anyone's toes with respect to the AEO designations.
Well, I think you're going to have to fix that because we have
Sure.
pretty strict rules about what we can do under seal. So if you
Sure.
could step, I understand the attorney eyes only documents,
Yep.
of course.
I could separate all of the filings if you'd like, if that makes things a little bit more neat and convenient for purposes of the ruling. Absolutely, Your Honor.
Okay, thank you. Then go ahead with any rebuttal that you would like, Mr.
Just
Carbo.
very briefly, Your Honor. The flash drive, just a few comments that I wrote down that I want to address. The flash drive doesn't tell us everything. That is correct. But it tells us something. It tells us that he had a flash drive, that he used at Sanitation Strategies, that he took with him to RMC with our files on them, and he accessed them while he was at RMC. So when you go back and talk about the conversion claims and the damages claims and why we want the things that we want, it's because when an employee goes to a new place of work with a flash drive in 2016, and he starts using it regularly, not just for solicitation of clients, but to build up his brand at the company, everything he created, whether it was with one of our customers or not one of our customers, because again, this is not a case where we're filing on a non-compete or a non-solicitation agreement. He stole our information and he used it against us competitively in the marketplace. So yes, our current clients are part of that. The clients he took are part of that. But how he and RMC used that in the marketplace is also a part of this. And we deserve to be able to see how that was done. That's why we've asked for those reports. Now, if Mr. Eldridge says they don't exist, then I'll take that certification from his client in writing and I'll ask for the metadata for the versions that do exist, so that we can show exactly how and when Mr. Livingston was using the things that he took with him against a sanitation strategy. So we deserve to have the right to know that, Your Honor, and that's all we're asking for here. In terms of whether or not the Brown University docs fall under the same category, Your Honor. They produced some documents from Brown University and we subpoenaed Brown University. Again, not a client of ours, but to see whether and how these materials were being used in their solicitations after Mr. Livingston came aboard. If he created things out of, without a flash drive and he goes out and does work based on his knowledge and expertise in the industry, that's one thing. But if he takes the playbook from Sanitation Strategies to a competitor and he uses it, we have the right to explore how, why, and when he used it, not just at deposition, but through discovery. And again, if we had known about the force, going back to the modification of Mr. Fannon's of the order governing Mr. Fannon's report, we knew about what we knew about because of what Mr. Livingston told us, and because of what we figured out to that point, the 3 flash drives. What you'll find in Mr. Fannon's deposition, I think, is that the search for how a flash drive is accessed and used is done in the same place. So he can't just close his eyes and not see the 4th one. There was no fishing expedition. We did not do the review, Mr. Fannon did. And he did not tell us what's on the 4th flash drive beyond what's in the letter that we submitted as an exhibit. So I can, again, resubmit that to you, Your Honor. We don't know. All we know is that he plugged it in and used it while he was at Sanitation Strategies, and then he took it with him and used it at RMC. I understand he says he doesn't have it now. That's not the point. The point is what he took, how he used it, and why he used it.
Okay, thank you. Let me just say first that Mr. Eldridge referenced a reply that was filed. I didn't get any reply. He is correct that a reply is not authorized under the court rules unless it's a motion for summary disposition. But even aside from that, if it were authorized, If I don't get a judge's copy delivered directly to me in my office, then you didn't file a reply. So I'm going to address these issues, and the first one is the laptop protocol. There was a stipulated order in this case. It was intended to prevent a fishing expedition where one side would have carte blanche access to the other side's hard drive. And those are exactly the types of overly broad discovery searches of electronic devices that, in my view, are never upheld in any court. They're just way overly broad. This particular stipulated order had a specific limitation that would prevent someone from just nosing around in the laptop. It was limited to discovering whether just 3 specific USB drives were connected to the laptop. It was limited to accessing only those files on the laptop that were also present on the USB device designated as FC55, and only for the purpose of verifying that the content was the same on both devices. And then it was limited as well to determining whether any employment-related files on the USB device FC55 are on the laptop now or had been on the laptop. Now the plaintiff's expert has discovered a 4th USB drive during his inspection. The plaintiff says this didn't violate the stipulated order because the 4th USB device was found while reviewing the USB activity on the laptop. That seems to me dubious at best because the plaintiff's counsel had previously described the inspection process as involving a search for the 3 USB devices by their identifying information and limiting the report only to what the search yields. He didn't say our expert's going to just look at the hard drive and search for any USB device that was ever connected to the laptop. He said that they were going to search by the identifying information of those 3 specific USB devices. So it would seem to me that this search has exceeded what was agreed to in the stipulated order. It's not like the criminal plain view doctrine. The plaintiff's expert had no right to just visually review all the USB activity at all on the laptop. I will not modify the protocol when it's already been violated. Furthermore, for me to expand the search of the laptop very late in a discovery period that's already been expanded once, and now we're up to, I believe, 8 months of discovery. It expires or it ends next week. There would have to be something more about this 4th USB drive than just what I've been told, which is a similar folder structure. I mean, I have applied the rules of discovery in this case to promote discovery of true facts and not allow things to be hidden. That's why I've been, I think, really lenient and open-minded right from the beginning in this case about things like adding conversion and extending discovery. But there does come a time this late in the game when you have to say enough is enough, and something has to be pretty compelling in order to allow, under those circumstances, even more discovery in this case. So I am denying that aspect of this motion. That takes us to the Brown University documents that have been designated attorney eyes only. And the plaintiff here wants them to be de-designated, if that is a word, attorney eyes only, and made confidential only. But the problem that I have is the plaintiff doesn't tell me why. I mean, what is the compelling reason to take a document that we've already said is attorney eyes only, and for good reason, as counsel has pointed out, this is our RMC's client, and it is not one of the companies or the businesses listed as a lost opportunity by the plaintiff. So, why do we have to go from attorney eyes only to confidential? No one has explained what the need for that is. And although I'm sure everyone realizes this, it's not that the documents haven't been supplied. They've been supplied, they're just designated attorney eyes only. So if we're gonna relax that standard, I'd have to have a good reason, and I haven't heard one. The plaintiff also raises the issue of the documents regarding National Institutes of Health Rocky Mountain Veterinary Branch, I believe it is. The defendant confirms that there's nothing else that exists. If his client hasn't done so and has to give a certification of that, then so be it, but I can't order something to be produced when it doesn't exist. And then the plaintiff asked to delay the depositions that are scheduled for next week. The reason, again, is rather sketchy. The reason is resolution of these discovery disputes and other discovery disputes. These discovery disputes, as you've just heard, are now resolved, and I don't think there's a need to reschedule the depositions. And again, I haven't been informed of what other discovery disputes would necessitate rescheduling these depositions that have been hard fought as far as scheduling in the first place. What would justify that? Furthermore, any outstanding discovery issues, as counsel has pointed out, can be inquired into in the depositions. And then finally, the request is to extend discovery 60 days. I already did that once. I did it over the defendant's very strenuous objection. And again, as I've indicated, this has now dragged on for 8 months. I have really tried to give plaintiff every opportunity to discover the facts that go behind their claims, and I don't see good cause to extend it again. I would note too, I'm really sorry, I sincerely am sorry if Mr. Pacific is having a health issue, and I hope you'll extend my best wishes to him. I really do mean that. But on the caption of the case, I see not only Warner Norcross and Judd, but also Foster Swift as attorneys for the plaintiff, both big firms, well-known, excellent firms filled with lawyers. So even in spite of Mr. Pacific's unfortunate situation, I think there were plenty of ways to proceed with getting things scheduled and done in this case. The defendant has laid out extensively in the defendant's response all the efforts that were made to schedule depositions, to get the discovery wrapped up in the 60 days, and it seems that none of it is the defendant's fault. So I'm actually denying the motion in its entirety.
Thank you, Your Honor. We will clean up the docket with the filings, and then I'm sure Mr. Eldridge will prepare an order.
Thank
We
you.
will, Your Honor. We will, Your Honor. Thank you.
Okay, I think we have everybody, and you're all connected, correct?
Good afternoon.
Okay, this is Frankenmuth Mutual Insurance Company versus Reed Machinery Inc., docket number 19-763CB. This is the time set for hearing on defendant Reed Machinery's motion for summary disposition. And before we go any further, could I please have counsel's appearance for the record? Plaintiff first.
Philip Carroll, your afternoon. Let me try that in English. Philip Carroll, Your Honor. Good afternoon for Frankenmuth Insurance.
And good afternoon, Your Honor. John Prue on behalf of the defendant, Reed Machinery.
Okay, thank you. Mr. Prue, you may go ahead.
Thank you, Your Honor. As you know, it's been pretty well briefed by both parties. I'll try not to belabor the factual issues, but I think it might help just to go over some of the background to get an understanding of where we're at. So as you know, this matter arises out of a crane tip over during the laying down of a very large press on September 10, 2018. The parties to this matter are Campbell Press Repair, who was the co-plaintiff, and its commercial property insurer, which is also a co-plaintiff, Frankenmuth Insurance. The defendant, my client, Reed Machinery, is the defendant, and its commercial liability insurer is Colony Insurance. There's also a non-party involved in this, and that is the owner of the press, Engel Press, which is based out of Wisconsin. As a matter of background, the subject press was sold by my client in the summer of 2017 to Engel. Engel then turned around and contracted with Campbell to have the press refurbished and then shipped back to Engel in Wisconsin. Campbell then next hired Reed Machinery to transport the press from its facility to Campbell, stand it up, and remove the lower cylinder for a quote that Reed submitted for $16,450. Following those discussions with Campbell, the quote was revised and resulted in a Campbell purchase order to perform this work. In that purchase order, there is a mutual waiver of subrogation between Campbell and Reed. It's undisputed that Reed performed the first phase of the quoted work and was paid by Campbell for those services. On September 10, 2018, while performing the second phase of laying the press down to be transported, a Reed crane got pulled over, which resulted in the press falling to the ground and the crane tipping over, which resulted in damages to the press and also resulted in property damages to Campbell, including to a mill, some tooling, and some other items that Frankenmuth paid on pursuant to a claim submitted by Campbell. Frankenmuth did pay over $300,000 combined for all of the property damage. It appears the only issue now on the waiver of subrogation per Frankenmuth's briefing is the argument that there is no mutuality of obligation because Reed allegedly did not comply with the purchase order's terms on insurance. The court has a copy of the purchase order, and per the purchase order, Reed was to name Campbell as an additional insured on a products and general liability policy, and that the insurance was to be primary. It appears it's Frankenmuth's position that Reed did not do this, and since Conley did not pay on the Campbell property damage claim, there's no mutuality. It's as briefed by Reed, it's clearly set forth in the attachments and in the briefing that Reed did meet its insurance obligation because Campbell is an additional insured on a Colony policy, and it's also a primary policy. Those endorsements are referenced in the briefing, and the entire policy is attached for the court's review. There is appropriate coverage, and it should be noted that Colony, per that policy, has already paid Engel $153,543 to settle the Engel business interruption claim. Colony also has on the table right now $210,000 to settle the Campbell claim for the expenses and costs that they incurred in fixing the subject press and returning it to Engel. So clearly, there's a policy in effect and benefits have been paid on it. The waiver of subrogation clause is valid and enforceable as to Frankenmuth. As the court may be aware, Frankenmuth, as the subrogee, stands in the shoes of the subrogor. Here, it's clear that Campbell agreed to the mutual waiver of subrogation, and as a result, Frankenmuth stands in the shoes of Campbell, and that waiver is applicable to it. So Reed obtained insurance, named Campbell's additional insured, and this insurance is primary for third-party claims. And the parties agreed to waive their rights to each other for claims or property losses arising out of the work. Let's assume, for example, Your Honor, that this accident happened because of the fault of Campbell, and the equipment that Reed had there got damaged. Reed wouldn't have a subrogation clause or its insurance carrier to go after Campbell. It would have been waived by this particular contract. And if Frankenmuth is entitled to reimbursement as it claims, what is the point of the waiver of subrogation clause in the contract? It makes it a moot point. And on the issue of rescission, Your Honor, it appears Frankenmuth claims that Reed did not provide the appropriate primary insurance, breaching the contract. And because of this, it's an argument that they're entitled to unilaterally rescind the contract. But as briefed and as I just indicated, Your Honor, and with the attachments that provided with the briefing, Reed did provide the appropriate primary insurance and did name Campbell as an additional insured. And as this court is probably aware, rescission is typically appropriate where there is a complete failure to perform the contract. That did not occur here. Reed got liability insurance with Campbell as an additional insured. This policy has settled one claim and is trying to settle a second claim with regards to third parties. And further, it's clear that Reed performed its services and was paid for those. This equitable remedy of rescission, Your Honor, under Michigan case law is considered to be a harsh remedy, and it cannot be invoked merely for the purpose of escaping what subsequently develops to have been a bad bargain. And that's exactly what's going on here, Your Honor. Frankenmuth doesn't like the fact that its insured contracted to waive its subrogation rights, and in turn, Frankenmuth's subrogation rights. So what they're trying to do now is get out of this deal, this bad deal, according to them. And there's really no basis for rescission. And finally, Your Honor, there's no evidence of mutual mistake here or unilateral mistake. This is Campbell's purchase order. They drafted it, they provided it. They're the ones who wanted a mutual waiver of subrogation, and they got what they contracted for. Thank you, Your Honor.
Thank you. Mr. Carroll? And
Yes,
I would
thank
note
you.
that I'm sorry, I would note in the middle of Mr. Prue's argument, Mr. Brown joined us and I let him in. Obviously, he's the attorney on the companion case.
Good afternoon, Your Honor. I'm just here to observe today.
That's what I thought, but I just thought I'd mention.
Thank you.
Okay, thank you. Go ahead, Mr. Carroll.
Thanks, Your Honor. I appreciate it. So, Your Honor, we have an invoice that both parties acknowledge was not signed. We have both parties acknowledging that that invoice required Reed to perform rigging. We all acknowledge that that rigging was done. We all acknowledge that the parties accepted and understood that Reed was to rig out this piece of equipment and was to be paid for that work. And we know ultimately that Reed accepted that job and performed the rigging. And we know that it was paid at least for purposes of the first part. And when the second aspect of rigging occurred, again, which was the subject of this invoice, this loss occurred. So the parties aren't in any way disagreeing on those issues. The problem that's arisen here is Reed wants to take that unsigned contract and say that it's enforceable based on the actions of the parties. And they want to look at the waiver provision myopically. Basically, that's the one aspect of this invoice they want to look at. The issue, though, is that that subrogation waiver does not stand alone. It is not the only concept that is reflected in this invoice. That waiver is an insurance provision that waives any mutual claims that the parties may have for payments that were made. Well, the payments that were made would be insurance payments, and there is express insurance provisions in that invoice. And so the court is asked to look at not only the waiver as an insurance concept, but the other insurance provision that is inexorably linked to it. Because the reason that you waive something is because you're acknowledging the manner in which the insurance payments are going to be, or the insurance obligations are going to be borne by those parties. And so if we're going to adopt the contract as enforceable, you need to look at the insurance obligations for both these parties, not just simply the waiver. And the insurance obligation as it relates to Reed and Campbell is clear. It says that Reed is to provide insurance, and that insurance is to be primary, and that Campbell is not to contribute to that insurance. And why is that so crucial here? Because it's clear, Your Honor, that Campbell agreed to bring Reed in and pay for services for safe and appropriate rigging, and had in its invoice to say, if something goes wrong and we suffer damage, not third party, first party, any damage, the invoice is clear, Reed is to provide the only insurance. And as a result of that acknowledgement of that insurance obligation, then there is the statement that the parties will then waive any subrogation rights for losses arising from this contract. And so this isn't a circumstance, as Mr. Prue puts it, as getting a bad deal. This is really a situation, Judge, where it's pretty clear as to what the parties expected from insurance. It never expected that Frankenmuth would pay $1. That's because the insurance obligation was solely borne by Reed. And so to turn around now and to say and accept Reed's argument, you end up in a situation where Reed gets the benefit of a contract to do rigging which they negligently performed, causing property damage for which the invoice expressly requires them to insure against. And then when Reed does not satisfy that insurance obligation and Frankenmuth is forced to step up and pay for the fault of Reed, Reed then hops up and says, surprise, we have a waiver for you. You can't get us for the monies that you've had to now pay. And this is clearly unequitable, and it's clearly contrary to the policy. Mr. Prue points out the fact that they have made payments. They have made those payments recently, Your Honor, meaning this loss, as you may tell, is several years old. There was never any offer to satisfy the claims for the property damage and the mill, and specifically, Campbell was and had conversations with Reed, and they were present at the time of the event and knew of the property damage and damage to the mill that's the subject of this insurance claim. So the ultimate circumstance here is, Judge, that if this court grants the subrogation waiver, it is cutting off the other insurance obligation that was accepted by Reed, that meant that they were to pay $1 and every dollar thereafter, and puts Frankenmuth in the unequitable situation of now having to jump in to assist for the obligation that Reed failed to satisfy, and now is being punished for that. Thank you, Your Honor.
Thank you. Mr. Prue, you want rebuttal time?
Yes, Your Honor, I'll be brief. First of all, Your Honor, the purchase order does not say that Campbell is not to contribute with regards to these losses of the policy. And also with regards to this being inequitable, Your Honor, this is expressly what these waiver of subrogation clauses do. The Michigan cases that have looked at waiver of subrogation have looked at very similar circumstances such as this, where the property insurer for the claimant, pays, and turns around and wants to subrogate. And it turns out there's a waiver of subrogation clause, and Michigan courts have consistently upheld the waiver of subrogation clauses, saying that they're valid and enforceable, especially here where it's a mutual waiver of subrogation. The equities flow back and forth between Reed and Campbell. This is not a one-way street. And Your Honor, with regards to the statement that Colony hasn't made any payments or made an offer of payment to Frankenmuth, I'm not sure why they would do it when there is a valid enforceable contract per the testimony of the principal of Campbell Press, Mr. Campbell, that this contract is valid and enforceable, which includes the terms in it. So why would Colony pay until there is a resolution of this issue on this contract? And also there's a dispute as to what amounts should have been paid by Frankenmuth. So those are issues being litigated. And finally, Your Honor, in the contract itself, there is no indication that these insurance obligations are a condition precedent to the enforceability of the waiver of subrogation clause. The waiver of subrogation clause can stand on its own, Your Honor. Thank you.
All right, thank you.
Your Honor, could I just have 2 seconds to respond? Do you mind?
I usually mind, but you can have 2 seconds.
Okay, thank you. I just wanted to address the invoice specifically says that, wait, I just lost it. Hold on. There you go. Any insurance Campbell Press repair shall have will be in excess coverage and non-contributory to the subcontractor's policy, which is Reed. So when I made that comment, it does say that it's non-contributory. And we're not arguing, Judge, that a subrogation waiver is not enforceable, but you can't enforce it in a vacuum. And the reason it was in there was because of the insurance obligation borne by Reed. Thank you, Your Honor.
Okay, thank you. Well, the defendant's motion argues that the plaintiff's claim is barred by the waiver of subrogation clause that's in the purchase order. And the plaintiff's argument is that the waiver of subrogation clause shouldn't be applied, either because it's unenforceable or because Reed materially breached the contract and the contract may or should or is rescinded. Now, I would mention that the plaintiff has referenced here the purchase order as being unsigned, but that was not the grounds upon which they briefed anything regarding enforceability. Both of their arguments that it's unenforceable and that it was materially breached and should be rescinded are based on legal arguments that they're based on Frankenmuth's contention that Reed failed to provide the insurance that was required under the purchase order. The purchase order, I won't read the whole thing, but the provisions regarding the insurance are the subcontractor shall add Campbell Press Repair as an additional insured to products liability and general liability insurance. The subcontractor's insurance shall be primary, and any insurance Campbell Press Repair shall have will be excess coverage and non-contributory to the subcontractor's policy. Now, there's more, but those are the basic insurance provisions in the purchase order. Reed, the moving party in the C10 motion, has come forward with supporting evidence to show, first, Campbell Press was added as an additional insured on Reed's policy with Colony Insurance. That's supported by Exhibit 7. The policy had an endorsement, and an endorsement indicating that it's primary and non-contributory. And there was a riggers extension that covered property damage from lifting up, moving, and setting down of materials by means of a mechanical device. That's in Exhibit 1. And the riggers extension was in effect on the date of the incident, which was September 10, 2018. Frankenmuth has failed to rebut that evidence or show that there's any genuine issue of material fact just by making repeated claims that Reed's insurance didn't pay for this. I can't discern anything from that other than it did not pay. I've been racking my brain trying to read depositions and figure out the reason why it didn't pay. I don't know the reason why they didn't pay. But the point is, there's no showing that Reed breached any provision in the purchase order, because as I've said, there were 3 main provisions about the insurance, and in this C-10 motion, they've shown, and no one has shown anything to the contrary, that they did what they're supposed to do. I would just add, Frankenmuth also points out that paragraph 9 under the terms and conditions of the purchase order provides customer agrees to carry and maintain insurance policies covering all of customers' potential liability as provided herein. But again, just by pointing that out, Reed has shown that it did provide the required insurance, and Frankenmuth has failed to provide any evidence of a breach by Reed or a genuine issue of material fact as to whether Reed breached the provision. The plaintiff says it's inequitable, and I understand that argument, but I would say maybe it is and maybe it's not, because I don't think it's inequitable to apply religiously the rules regarding a C-10 motion. I don't think it's inequitable to enforce an unambiguous insurance contract, and I don't think it's inequitable to enforce a waiver of subrogation clause that the parties agreed to. And yes, I did read the case, and I know there's more than one, but the one in particular that I was pointed to, that these are done, and this is what they agreed to, and I see no reason why it's inequitable to enforce that. So I am granting the defendant's motion for summary disposition under C-10. And Mr. Prue, if you want to submit an order stating for the reasons stated on the record.
I will do that, Your Honor.
All right, thank you, everyone. That'll conclude our hearing.
All right, have
Thank
a
you,
good day,
Your
Your Honor.
Thank you, Your Honor.